Testing 1 2 3. Testing 1 2 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode: Jenn Kamp files for bankruptcy. If you recall from the last episode I did about the civil lawsuit down in Utah between John Dehlin, Open Stories, and Jenn Kamp, Jenn Kamp has already been found to have committed defamation against John Dehlin and Open Stories. And last episode, we went over some of the things that were going on in the background that Jenn Kamp was engaged in. The first of those things happened on May 7th, 2024, when Jenn Kamp quitclaimed her interest in the family home to her husband, Jason Kamp. And here we have a copy of that document. This is the family home, and this quitclaim occurred on May 7th, 2024. You can see that there in the upper right-hand corner, second line, May 7th, 2024 at 3:50 p.m. So Jenn Kamp quitclaims her interest in the family home to her husband, Jason Kamp, which means she gives every bit of her interest in the home to her husband. Whatever interest she has in the home is given to her husband. That's the meaning of a quitclaim deed. It gives every interest you have without qualification. So now she has divested herself of her interest in the family home on May 7th, 2024. The next thing that she did was that she filed for divorce against her husband the following month on June 11th, 2024. And although the petition itself is private, there are other documents in that file that are not private. Here's one of them, the Standard Domestic Relations Injunction, which you can see was filed on June 11th, 2024 at 10 o'clock a.m. in the 3rd Judicial District of the Salt Lake County District Court. You can see that Jenn Kamp is the petitioner in that case. In other words, she's the one who filed for divorce, and Jason Kamp, her husband, is the respondent. And there you also have the case number for the divorce as well as the judge to whom that case has been assigned. So a quitclaim deed on May 7th and then filing for divorce on June 11th is what Jenn Kamp has been engaged in behind the scenes. Also going on behind the scenes is that they placed their house, or I should say Jason placed his house now on the market. And indeed, my understanding is that it was under contract and that sale on the house was set to close on July 31st of this year. All of that was going on behind the scenes, or in other words, outside of the civil case down there in Utah between John Dehlin and Jenn Kamp. So it appears that the attorneys for OSF and John Dehlin got wind of what was going on behind the scenes, and therefore they filed a motion with the court for a temporary restraining order in order to prevent Jenn Kamp and or her husband Jason from selling the family house, so that by the time it came for the damages hearing on the civil case in August, they wouldn't have any more assets or any assets to speak of. The primary asset, the family home, would have been moved out of Jenn's name and then sold to somebody else. So it could not be attached in the civil case in order to repay some or all of the damages awarded by the judge in August. So as I say, John Dehlin's attorneys had filed for a temporary restraining order. They filed for it on an emergency basis, and that motion was scheduled for Monday, July 8th, just this past Monday, July 8th, 2024 at 9 o'clock in the morning. What Jenn Kamp did was she went to the judge and asked for a continuance of the case for 2 weeks. Why? Probably so the sale of the house could go through. But she asked for it for some reason. I don't know. Once again, the judge has made documents in that case private, so I'm not able to access them anymore and show them to you on the screen. But we can still look at the docket for the case, and there's a lot of information we can get from that. In other words, it tells us what motions are filed, and to some extent, it'll tell us what rulings are made in the docket of the case, even though we don't have access to the actual documents themselves. So Jenn Kamp filed a motion for a 2-week continuance from July 8th, when it was already set out for 2 more weeks. We know from the docket that Judge Faust denied that request for a continuance for 2 weeks. And I believe Jenn Kamp's motion for the continuance was filed on Wednesday, July 3rd. Of course, July 4th, Thursday, was a holiday, so there was no court in session. And that Judge Faust denied that motion on July 5th, 2024. In other words, on the Friday, before the weekend, before the Monday hearing on the temporary restraining order. So what Jenn Kamp did in a completely unexpected move, Not to be deterred, Jenn Kamp went and got an attorney and filed for bankruptcy over the 4th of July weekend. Now, I did not know about this until the evening of Sunday, July 7th, even though it appears that she filed for this bankruptcy 2 days earlier on July 5th, on the very Friday on which her motion to continue was denied. Yeah, she had this ready to go, it looks like. And here is an email that I received from her attorney regarding the bankruptcy and everybody else who has anything to do with this case, i.e., any creditors, any people that she feels have a claim against her. She had to list down, and strangely enough, she put me down, not once, but twice, actually. So therefore, I am on the list of people who get these notifications. And here's the notification that I received on Sunday evening from her new attorney, a bankruptcy attorney. And here is that email. I have whited out the email addresses for all the different parties, but other than that, this is pretty much the entirety of this email. And here is what it says. Sunday, July 7th, 2024. This is in the upper far right-hand corner. I know it's a bit small on the screen. I apologize for that. But that is the date that this was sent at 4:13 p.m. So at 4:13 p.m., the Sunday before the 9 o'clock a.m. hearing in Utah, this email was sent notifying the parties, myself, as well as John Dehlin, as well as OSF, as well as their attorneys, that Jenn Kamp has now filed for bankruptcy. And here's what it says. Notice of bankruptcy. Jennifer Kamp, Open Stories Foundation, et al. Versus Jennifer Kamp, et al., cause number so-and-so. And that is the case number down there in Utah, giving notice of bankruptcy. All, that's how it starts. Not dear, just all. Please see attached the notice of bankruptcy filed in the Western District of Washington at Tacoma. Now, this is surprising. It's filed in the Western District of Washington at Tacoma on behalf of my client, Jennifer Kamp. So this is the first surprise. The filing for bankruptcy, really not that much of a surprise. We were all kind of wondering when it was going to happen. It wasn't a question of if, it was just a question of when. And it looks like the judge denying Jenn Kamp's motion for that 2-week continuance may have forced her hand and caused her to act a little more precipitously in this regard, i.e. filing for bankruptcy, than she would otherwise have done. But it says the Western District of Washington at Tacoma. A little bit of background. Bankruptcy courts have different districts. There's lots of bankruptcy courts throughout the United States. They're not in counties, they're not in states, but they are in districts. So, for example, the district in Western Washington takes up Western Washington, basically on the western side of the Cascades. There's another district on the other side of Washington. If you are going to file in a particular district, there are certain jurisdictional requirements, and they're not complicated. The main jurisdictional requirement is that you have to have lived in that district and had residence in that district for the majority of the last 180 days. So at least 91 of the past 180 days before filing, you have to have lived and had a residence there in that district in which you're filing. That's what's required in order to have jurisdiction. That's what's required in order to file there, at least under the law. Now, it's a surprise to me that Jenn Kamp is up here in my home state. Actually, she's only about 2 hours away, but I don't have a drone hovering over her house and keeping track of all of her movements either. I'm just going to say that this was a surprise. And I don't know, did she quit her job? Is her job something that she can do remotely, as remote as Washington? All these questions I don't have answers to, but I do have a lot of questions. Going on with the email. Please see attached the notice of bankruptcy filed in the Western District of Washington at Tacoma on behalf of my client, Jennifer Kamp. I have drafted the notice with the case header for filing with the 3rd District Court so that the bankruptcy notice may be filed in the case. So in other words, they're filing the bankruptcy in Tacoma, but they're also giving a notice in the Utah court that this has been filed. And we'll talk a little bit about why that's important here in a second, and the effect of Jenn Kamp filing for bankruptcy on the civil case in Utah. As you may be aware, the email continues, the automatic stay is one of the fundamental debtor protections provided by federal bankruptcy law. This is the effect, all right? There is an automatic stay as soon as Jenn Kamp, or any person, but in this case, Jenn Kamp, as soon as she files for bankruptcy, that means that any other case against her, and or any other collection action against her for any reason gets automatically stayed. It is stopped cold, and no one can continue to proceed against her in a different court for collection of a debt or in a civil case like the one that John Dehlin and OSF have going against her. That has to stop immediately. So the effect of filing for bankruptcy over the weekend meant that the Monday hearing in Utah could not go forward. It was stopped dead in its track. Now, you may be saying, okay, so what happens to the case? Well, bankruptcy court is a very powerful court. It's like a super court. It is more powerful than almost any other court in the United States. And by that, I mean that as soon as a petition for bankruptcy is filed, the civil case has to stop. And now the bankruptcy court assumes jurisdiction over the civil case. Any claims in the civil case are now going to have to be litigated in the bankruptcy court. Bankruptcy court now has jurisdiction over these claims as long as you file and let them know that you have these claims. And that's why the notice has to go out to all of these parties so that they can know not only that the case in Utah is stopped cold, but that there is a court, a bankruptcy court, where they can file to pursue their claims in bankruptcy court. Now, I've got to tell you this as a bit of background. On me personally, I have never practiced bankruptcy law. I took the class once. It was in 1988. I don't remember a lot from that class, believe me. But what I did on Sunday evening was I called two friends of mine who are attorneys who do practice bankruptcy law, and I got a quick refresher course on the whole thing. So let's continue with this email. It, i.e. the filing for bankruptcy, it gives the debtor, Jenn Kamp, a breathing spell from creditors. It stops all collection efforts, all harassment, and all foreclosure actions. It permits the debtor to attempt repayment or reorganization plan, or simply to be relieved of the financial pressures that drove them into bankruptcy. It is my understanding that there is a hearing tomorrow morning regarding this matter. See the email going out on Sunday afternoon, late, right before the Monday morning hearing. It is my understanding that there is a hearing tomorrow morning regarding this matter. The filing of this bankruptcy petition acts as a stay of the hearing and all future hearings while the bankruptcy stay is in effect and is pending until the bankruptcy court otherwise. And I think he meant to put rules otherwise or orders otherwise, until the bankruptcy court orders otherwise. I have attempted to give notice, by which I think he meant I have attempted to give notice through this email to attorneys that currently represent the parties or maybe creditors in this bankruptcy case. If counsel for one of the parties has not been notified, please advise. Please let me know if you have any questions regarding this. Thank you, David. That's David C. Smith, who is an attorney with his offices in Tacoma. He is a bankruptcy attorney. And by the way, it occurs to me as I'm reading through this that this may be the reason that my name is on the list, because it talks about any attorneys who represent the parties, and Jenn Kamp may well still be under the misguided notion that I represent anybody in this case as an attorney. However, this may work to my benefit because I'm getting the documents. I'm getting the emails because I'm put on the list of people who have to be notified. So let's look at that notice of bankruptcy that they filed in Utah, in the Utah case, to give them notice that indeed the hearing could not go forward on Monday morning because bankruptcy had been filed in Washington. You can see it's filed under the title of the civil case down there in Utah, and it's called Notice of Bankruptcy Filing and a 362 Stay and Certificate of Service. Notice of Filing of Bankruptcy Petition. Notice is hereby given that Jennifer Kamp has filed a petition for voluntary Chapter 13 bankruptcy in the United States Bankruptcy Court for the Western District of Washington at Seattle. Now, I'm not sure if this is filed in Seattle or in Tacoma because there are courts in both Seattle and Tacoma, and it's not clear. It seems to go back and forth as to whether it's Tacoma or whether it's Seattle. Either way, it's definitely in Western Washington District. Let me give you a brief synopsis of what Chapter 13 means. She's filed under Chapter 13, which means she's planning on repaying some or all of the debts that she owes. In short, what happens is that she has certain creditors who are after her for money. And now she's going to have to present a payment plan to the trustee. The trustee is the person in the bankruptcy court who's assigned to a case. Every bankruptcy case has a trustee assigned. And the point of having a trustee and the trustee's job is to come up with a repayment plan that to the largest extent possible pays back the creditors in accordance with the law. Now, it will be up to Jenn Kamp to create a repayment plan, and a repayment plan will go for either 3 years or 5 years. She has to come up with it. She has to propose it. It has to be affirmed by the trustee. And once that repayment plan is affirmed and adopted by the court, then Jenn Kamp has to pay the trustee a certain amount per month or every 2 weeks. Depending on the plan and depending on the arrangements that have made, she has to pay the trustee a certain amount of her income every month, which the trustee then disperses to the different creditors pursuant to the terms of the repayment plan. Once again, this repayment plan has no guarantee and usually does not repay creditors completely. Otherwise, the person wouldn't be filing bankruptcy in the first place. But it does take care of repaying the creditors something. At least if they're lucky, some creditors may get nothing. And here's the next part of it. Once again, remember, I have not ever practiced bankruptcy law. I did take a class on it once back at law school at the University of Texas at Austin in 1988, and I have had a refresher course by talking to 2 attorneys recently who do practice bankruptcy. So with those caveats out of the way, when you are creating the payment plan, when the payment plan is being adopted, there are 3 classes of creditors, and the one class of creditor has top priority. They're going to be repaid first. There's a second class of creditor that once the top class of predators, there's a second class of creditors as well, and a third class of creditors. So the first class of creditors, once they're paid off, then the second class of creditors takes their turn in line, and then they begin to get paid off. If they get completely paid off, the second class of creditors, then you go to the third class of creditors, who then get some of the money from the bankruptcy. And you can guess that in a bankruptcy case, the first class of creditors, that's where you want to be. Now, the first class of creditors is basically the government, okay? So the government is going to get its money off the top. If you owe the government money, or if Jenn Kamp owes the government money, then they're going to get paid first, right? They are in the catbird seat. They get paid back first. If there's any money left after that first class, the government gets paid off on the debts that are owed to them. Then it goes to the second class of creditors. The second class of creditors are those who have a secured debt, and the third class of creditors are those who have an unsecured debt. So what is a secured debt versus an unsecured debt? Well, at a very basic level, if I were to tell you that I need $10 and I will give you my watch for $10, but that when I come back and repay you, you give me my watch back, right? Okay, that $10 is secured by my watch. It is secured by property because you're going to be holding the watch. And if I don't pay you back, then you can take my watch, right? As security for the debt. Generally, it's much bigger things than this. And often it involves a house. So if there is a lien on the house or a mortgage on the house, that is considered a secured debt. The debt is secured by the house itself, so that if the person fails to pay the debt, then the person who has the lien on the house or the mortgage on the house can go after the mortgage to make themselves whole on the debt. Does that make sense? Okay, so if you have a secured debt, now you're in that second class of creditors. And if you have an unsecured debt, which means you owe me money legitimately, it may be reflected on paper, indeed, but it's not secured by property. That's the lowest classification. That's the most unprotected classification of creditor in a bankruptcy. So this plan, once it is proposed and once it is adopted by the court and goes into force, this 3-year or 5-year repayment plan, first off, the government will get repaid any money that is owed to it. Second off, any secured creditors will be paid off any money that is owed to them. And there is at least one secured debt in this case that we know of, because not only is there probably a mortgage on the house, not only that, but also Jenn Kamp's prior attorneys, who I think were Hepworth Legal. I think that was the name of the firm. Remember the ones who bailed in January? They split ways. Well, they came after Jenn in February and filed a lien on her house for unpaid attorney's fees, which were in the neighborhood, I think, of $100,000. So Hepworth Legal has a secured debt, and they take that second place, that second classification of being a secured creditor in the bankruptcy case. So they have a leg up, not as high as the government, but better than anybody who has an unsecured debt. Which brings us now to John Dehlin and Open Stories Foundation. because they don't even have a judgment yet. I think they have a judgment for the first amount, like $12,000 of attorney's fees. They don't have a judgment yet, to my knowledge, on their much larger order for attorney's fees. And there's no order whatsoever on what the damages are, because that hearing hasn't even been held yet. That was going to be held in August, but now that's off the calendar as well. All of this is going to have to take place in bankruptcy court. But the civil case with John Dehlin and OSF is, to the extent that there is any debt there, it is unsecured, which means the government gets paid first. People with secured debts get paid second. People like the bank that has the mortgage on the house, Hepworth Legal, will get paid second. And if there's any money left after that, which frankly is unlikely, then it goes to those with unsecured debts, like those held by John Dehlin, at least to the $12,000 in attorney's fees that has already been entered. Once again, that is the only judgment of which I'm aware that has actually been entered in that case. So it doesn't look like John Dehlin and OSF are going to be getting a lot of money out of Jenn Kamp through this bankruptcy. Now, there are a lot of moving parts here, because there are certain debts and certain actions that are not dischargeable through bankruptcy. Most debts are dischargeable through bankruptcy, but the law has carved out certain exceptions to that. And one of those exceptions may very well be defamation. So what that means is the attorneys for OSF and John Dehlin can go to bankruptcy court and ask the bankruptcy judge to order that this defamation lawsuit going on in Utah is not dischargeable in bankruptcy, and therefore they can proceed with the civil suit in Utah. Of course, that raises the question, what is the point of proceeding with the civil suit in Utah when the judge has already found Jenn Kamp to have committed defamation and you haven't figured out what the damages are yet? What is the point of going through a hearing to determine what those damages are when all of Jenn Kamp's assets are in bankruptcy court being divided up among other people there? So that's the question that attorneys for John Dehlin and OSF are going to have to be struggling with. Is it even worth it to go to bankruptcy court and ask that this defamation suit be removed from bankruptcy court and put back in Utah when there's nothing going to be left to go after, because it's all going to be in bankruptcy court? Or should they stay in bankruptcy court and hope that after the government is paid on the first level of creditors, and then the secured creditors are paid out of the second level of creditors, there's going to be anything left over, which I think is highly unlikely, for people like John Dehlin and OSF who are unsecured creditors? So that's a decision that they're going to have to make. And neither option seems especially attractive at this point. I suppose at least John Dehlin and OSF have the moral victory of the fact that Jenn Kamp was found by the judge to have committed defamation against John Dehlin and OSF, even though they may never see a penny from Jenn Kamp for all the attorney's fees that they paid because of Jenn Kamp's malfeasance, and not a penny for the defamation that Jenn Kamp caused John Dehlin and OSF. Let's continue going through this document, shall we? This bankruptcy petition acts as an automatic stay on any civil suits, including the defamation suit, which is why it's being filed there in the Utah court, to notify them of that fact and let them know they can't proceed any further with their case in Utah until such time as the bankruptcy case is over. And the bankruptcy case will almost certainly take care, one way or another, of this defamation case in Utah. And then this final line, the automatic stay is one of the fundamental debtor protections provided by the bankruptcy laws. It gives the debtor a breathing spell from creditors, i.e., it gives Jenn Kamp a breathing spell from John Dehlin. It stops all collection efforts, all harassment, and all foreclosure actions. So if you're in debt to somebody and they're calling you on the phone and bugging you all the time, that has to stop as well. I don't know if that's been happening in the Jenn, but that's the kind of thing that can happen and the kind of thing that this automatic stay stops in its tracks. It permits the debtor, Jenn Kamp, to attempt repayment or reorganization plan, or simply to be relieved of the financial pressures that drove him, or her in this case, into bankruptcy. Willful violation of the automatic stay provisions may subject you to contempt of court proceedings. So these protections are very serious. If you continue to go after somebody for a debt or continue a legal action against somebody after having received notice that they filed for bankruptcy, that can be contempt of court, i.e., contempt of the automatic stay order in the bankruptcy court. So this notice of bankruptcy was signed on July 7th, 2024, which was Sunday. You can see it signed there by her attorney, David Smith. And here's the certificate of service on the people that it was served on. I was one of those people. I have redacted that, but I was one of those people to whom it was served, which is why I have these documents. And it was signed the 7th day of July, 2024, once again on Sunday. Now, down here, we have the actual notice of bankruptcy case filing, and you'll see over there in the seal, it has a different date. It says it was filed on July 5th, 2024 at 9:19 p.m. Obviously, electronically, the courts are not open at all hours, but filed on Friday night. So I'm not sure why it was filed on Friday night, and then nobody was notified of it until the evening before the hearing, but apparently that's the way it happened. The notice of bankruptcy case filing says a bankruptcy case concerning the debtor listed below, which is Jenn Kamp. I have redacted her address as well as her apartment number, but in Gig Harbor, Washington, 98335. I have to mention something. Gig Harbor is a very affluent community. There are a certain handful of communities, probably in any state or area, that a person who's lived there for a long time could name off the top of their head. And in Western Washington, those places would be Gig Harbor, Mercer Island, possibly Bellevue as well. These are the really nice areas. There might be a couple more, but Gig Harbor, very affluent. So I'm guessing that if Jennifer Kamp is actually living in an apartment in Gig Harbor, that the rent has got to be through the roof. I mean, my rent is already through the roof. Everybody's rent is through the roof. Gig Harbor got to be super through the roof. I've got to imagine it's more expensive than the average rent because of its location. And here is the trustee who has been assigned to the case, Michael Malayer, I'm guessing is how that last name is pronounced. He is the trustee for the case, David Smith being Jenn Kamp's attorney on the case. And the case has been assigned a case number, and it's been assigned to Judge Mary Jo Heston. Boy, does that judge not know what's coming her way, but she's going to find out, just like Judge Faust did, I imagine. And then this notice of bankruptcy case filing has the name of the clerk of the U.S. Bankruptcy Court, Gina Zadra Walton, right there in the bottom right-hand corner. Okay, that's about enough of the documents. There are some other documents, but they're mainly duplicative. I want to talk about two more things before I leave, two important things. The first thing has to do with the quitclaim deed that Jenn Kamp did to her husband on May 7th, 2024. That will be undone by the bankruptcy court. Bankruptcy law includes what's called a look-back provision. And the easiest way I can explain it to you is this. Since time immemorial, since the very creation of the bankruptcy courts, there have been people who have wanted to go into bankruptcy, but they didn't want to lose their assets. So what they did was, say they have a piece of property and that's their main asset, like the family home maybe. They take the family home and then they quitclaim it to somebody else with the understanding that after bankruptcy proceedings are over, then their friend, their husband, I don't know, will quitclaim the house back to them or give them back the interest in the house that they gave to them before bankruptcy. So this has been going on, as I say, since time immemorial. And what has developed over the years, and it was certainly the law back in 1988, and it probably wasn't a new law then, it's called a look-back provision. So you can look back 90 days, 180 days before the filing for bankruptcy. And if the person filing for bankruptcy has transferred any assets to anybody else during that look-back period, the bankruptcy court is going to undo those transfers and put them back the way they were originally. Yeah, they're not going to be allowed to get away with this. And specifically, as it applies to Jenn Kamp's case, what's going to happen is that quitclaim deed that she did to her husband at the house back on May 7th of 2024 is going to be undone by the bankruptcy court. This is the closest thing in the law you'll get to a sure thing. I fully expect that's going to happen. The quitclaim deed will be undone. And so then the house will once again be Jenn Kamp's property along with her husband, and therefore be able to be taken into consideration in the bankruptcy court. Now, on the other side of that, as I recall from bankruptcy class, there is in bankruptcy what's called a homestead exemption, which means that no matter how bad things are for a person who's filing for bankruptcy, if they have a home, they get to keep it. If they have 5 homes, they don't get to keep all 5, but they do get to keep their home so that they are not thrown out of their house and made homeless. So what may end up happening is that this quitclaim deed will be undone, The interest that Jenn Kamp has in the house will once again be restored to her, and the bankruptcy court may protect that house. I don't know. But once again, she's now living in Washington. So what does she need the house for? This is going to get very, very complicated very fast. And I think that Jenn Kamp is going to make as big a mess in bankruptcy court as she made in civil court in Judge Faust's courtroom. She's certainly off to a fine start as far as that goes. So that's the first thing I wanted to talk to you about, the almost inevitable undoing of the quitclaim deed by the bankruptcy court, which I expect will happen. The second thing is this: Jenn Kamp had this house on the market, or her husband had it on the market, however you want to say it. The house was on the market to be sold. First, she had quitclaimed it to her husband, then it's on the market, then apparently it's under contract, and then it was scheduled to close July 31st, 2024. Now, assuming that that's what Jenn Kamp wanted to happen, i.e., she wanted this house to sell, her filing for bankruptcy ends up undoing that completely, because as soon as the trustee learned on Monday that she had quitclaimed her interest in the house to her husband, who was now selling the house and it was on the market, that got put the kibosh on. That house is not selling. That sale is over. There's no way any self-respecting bankruptcy trustee is going to allow those kind of shenanigans to happen, because he is there to preserve the property. Remember, that's the trustee's job, and make sure that within the parameters of the law, the available assets are distributed to the creditors. So that house sale is done. It's history, because Jenn Kamp filed for bankruptcy. So what I'm saying is, if Jenn Kamp really wanted that house to sell, then she never should have filed for bankruptcy, because as soon as she filed for bankruptcy, the sale of the house was frozen. It's not going to sell. It's going to have to be dealt with in bankruptcy court as part of the repayment plan, and possibly as part of the homestead exemption. But that sale is done. It is over. It is not happening. So it is possible that Jenn Kamp inadvertently acted against her own interests in filing for bankruptcy. To the extent that Jenn Kamp may have thought that filing for bankruptcy would give more time for the house to sell and for it to close on July 31st, that hope was blasted by the bankruptcy laws and the fact that not only is there a look-back provision that undoes transfers of assets, prior to filing for bankruptcy, you sure as hell can't transfer assets after you filed for bankruptcy. And even though she quitclaimed it to her husband to say, oh, it's her husband's house, that quitclaim that she did in May is going to be undone by bankruptcy court as well. So that's the situation that Jenn Kamp finds herself in. And that's the situation that John Dehlin and OSF find themselves in, due to Jenn Kamp filing for bankruptcy over the 4th of July weekend. So beyond those general observations, I don't have much of any specificity to share with you at this time. However, because I am listed as a creditor or a lawyer for one of the creditors, I should be getting a lot of documents related to this bankruptcy, and all documents filed in bankruptcy court are public as well, I should add. But I should have them delivered to my doorstep by email. And if any of those documents contain interesting information and we find out what's happening with this bankruptcy, I will be sure to let you know. So that's about all for tonight. Please hit like, please hit subscribe, please leave a comment below. Thank you to all my donors. Without you, Radio Free Mormon could not broadcast behind enemy lines. Until next time, this is Radio Free Mormon, signing off the air.